The following program is brought to you by Stetson University College of Law, the National Clearinghouse for Science, Technology, and the Law, and was funded by the U.S. Department of Justice Bureau of Justice Assistance Capital Case Litigation Initiative.
Welcome to Drug Chemistry Essentials, Importance of Standardized Forensic Methods for the Analysis of Seized Drugs, the 10th in our series of webinars for the Bureau of Justice Assistance, Capital Litigation Initiative, Crime Scene to Courtroom Forensics Training. This webinar is produced by the National Clearinghouse for Science, Technology, and the Law and the Office of Professional Education at Stetson University College of Law. I am your host, Jose Almiral. I am a professor in the Department of Chemistry and Biochemistry at Florida International University and director of the Center for Advanced Research in Forensic Science. Today's webinar will provide insight into seized drug analysis methods and procedures, as well as legal application of analyses findings. Our expert panel will discuss the importance of standardized forensic methods for seized drug analyses and the impact this has on laboratories in different jurisdictions. The webinar delves in the significance of laboratory accreditation, quality assurance, and legal relevance of the forensic evidence discipline in the courtroom. Discussions address resources, emerging concerns, and considerations for seized drugs documentary standards, which may impact how this evidence is utilized in the courtroom. Joining me today on the panel are Dr. Sandra Rodriguez-Cruz and Mr. Alec Hall. Dr. Rodriguez-Cruz is a senior research chemist at the Drug Enforcement Administration, Southwest Laboratory. She started her career with DEA in 2002. She is certified as a drug analyst fellow by the American Board of Criminalistics. She is the fellow of the American Academy of Forensic Sciences and a member of the Clandestine Laboratory Investigating Chemists, CLIC Association, as well as ASTM International. Sandra also serves as a Secretariat of the Scientific Working Group for the Analysis of Seized Drugs, SWGDRUG, and is the current chair of the Seized Drugs Subcommittee within the National Institutes of Standards and Technology, Organization of Scientific Area Committees for Forensic Science, or OSAC. Dr. Rodriguez-Cruz completed her BS in Chemistry at the University of Puerto Rico, Rio Piedras, her PhD in Chemistry at the University of California, Berkeley, and a postdoctoral fellowship at the Rowland Institute for Science in Harvard and Cambridge. Alec Hall is an assistant federal public defender, Middle District of Florida. Mr. Hall has over 20 years of experience handling high-level state and federal criminal trial work as both an attorney and a probation officer. Mr. Hall is a graduate of the Nova Southeastern University Shepherd Broad Law Center. And about our chat feature, while the webinar is in progress, you can chat with us at any time. Use the chat feature found on the right-hand side of your login screen, and we will answer as many questions as possible. Please note that we may not get to all your questions while on the air. However, we will answer all the questions that you send to us, and a Q&A document will be sent to all the participants by email. This webinar is designed for both prosecutors and defense attorneys. Attendees who complete this webinar will be eligible for continuing legal education credits, and the Stetson Office of Professional Education will work with each individual participant for reporting specifics. CLE applications will be made to Florida and other states per individual request. Please email ope@law.stetson.edu for further information and state-specific requests. As an intro to Dr. Rodriguez-Cruz's presentation, we've set the stage. The prevalence of drug-related cases has significantly increased and has made a major impact on the criminal justice system. Hardly a week passes by without media coverage, professional journal articles, or government agencies addressing this issue. Just this month, the DEA announced that Operation Task Force Arkansas, a joint takedown operation involving DEA, state, federal, and local law enforcement, arrested 1,260 individuals and seized 211 firearms, 37 kilograms of methamphetamine, over 1,200 pounds of marijuana, 47 kilograms of cocaine, and 1 kilogram of heroin. Controlled prescription pills, vehicles, and over $350,000 in U.S. currency. Sandra, as a DEA senior research chemist, whether dealing with small evidence samples or large quantities and a variety of drug evidence submissions, what should attorneys know about laboratory drug analysis methods and procedures?
Well, I'll be happy to try to attempt and answer that question today. First of all, thank you for the invitation. It's not routine for us to interact with members of the legal community out of the courtroom and for educational purposes. So I appreciate the invitation and participate on the panel. So let's go ahead and get started. I am going to attempt to go over the multiple areas that are involved during drug analysis. First of all, we'll start with the basic definition of what is it that drug analysis entails. Also through some quality assurance and accreditation processes that laboratories should have in place. We'll talk a little bit about terminology. I always think terminology is very important since we both need to understand the language that each other speaks. A lot of the time the miscommunication comes from the lack of knowledge on that terminology. Jurisdictional issues is a very important subject as it will determine not only the extent of analysis, but also the contents of a laboratory report that attorneys may receive prior to trial. I'll go through the laboratory submission processes, the types of samples that a laboratory routinely sees, and then we'll go into the steps of analysis, and there'll be 4 general steps that we'll discuss. Conclusions and laboratory reports, what you should expect them to contain, as well as closing with giving you information about the international and discipline accepted standards that are available not only to the general chemistry community and drug analysis community, but also to the legal community, as many of the standards are available for free. Well, drug analysis is a very well-established forensic discipline. It has been around for many decades, and it's based on the physical science of chemistry, mainly the field of analytical chemistry. And we have a very, very simple goal in the drug analysis laboratory, and that goal is to identify either one or more of the components that are present in a sample that's submitted for analysis in a typical exhibit seized either by a law enforcement officer or any other law enforcement personnel. Analytical chemistry is that part of chemistry where instruments or tests and methods are used to separate the components of a sample, identify them, and in many cases quantify them. In practice, a lot of these procedures can be performed independently, separated from each other, or be combined via the use of a technique that combines the 3 processes. We call it a separation analysis because we're trying to isolate the analytes in a similar way as you would try to isolate the components of your morning coffee into caffeine, milk, and sugar, water, and many others. Qualitative analysis is also part of analytical chemistry, as well as quantitative analysis. Qualitative analysis identifies the analyte, where the quantitative part tells us how much of that analyte is present. All these procedures should be happening in a laboratory that, among many other things, should possess a very strong quality assurance program. Why is this important? Because a quality assurance program will ensure that those reported results are scientifically valid. And not only that, that will give the basis to the opinions provided by the analyst or the opinions provided in the laboratory report, so that they're based on reliable results. Quality assurance programs should also include education requirements for the analysts that are performing the analysis. They should also specify evidence handling and policy and procedures that laboratories must have. They also provide guidance, in many cases requirements for the technical and administrative review of the analysis and the reports that go out to the customers. Distribution of reports are usually also specified within the quality assurance programs, safety and security procedures, requirements for the validation of the methods that are used in the laboratory, and also include testimony audits, as well as casework audits. And these all should happen within the framework of a laboratory accreditation. Laboratory accreditation is not mandatory throughout the United States. Only few states have made it mandatory. So a lot of the laboratories performing seized drug analysis do undergo voluntary laboratory accreditation. And there's over 300 laboratories throughout the US that have become voluntarily accredited in order to comply with a lot of these requirements and have provided quality assurance program within their laboratories. Let me speak a little bit about terminology, because as I said in the introduction, this is sometimes a subject that leads to confusion, because us as analysts are used to talking with other analysts like us that would understand what we say, except that when we go and put the same terms to an attorney or a legal professional, a lot of the times the communication doesn't happen. On the same token, when an attorney is trying to communicate with us, a lot of the times we are not familiar with the terms because we didn't go to law school and we're not familiar with the terms that they're trying to use to communicate with us. Terms that you may be familiar with already are terms like drugs, substances, chemicals, and analytes, and we as scientists may use these interchangeably as synonyms. And usually we use them when we refer to just one compound, like the drug cocaine or the chemical methamphetamine. We may also tell you about components, and we use that word when we refer to mixtures in a sample where there may be more than one drug present, more than one substance or chemicals. A lot of the times, and a lot of it based on the influence by TV shows, we hear the word narcotic to be used to reference to any type of drugs. For us analysts, narcotic is a specific type of drug. For example, an opioid or like heroin. Stimulants would be something more fitting to describe cocaine or methamphetamine. Depressants are something more dedicated to drugs that can depress the central nervous system. Hallucinogens are only drugs such as THC as well as LSD. So it often confuses us when somebody uses the word narcotic to refer to any type of drug. Obviously, we also refer to those substances that are controlled by law, either at the federal level or at the state level. But there's also chemicals that are known as listed chemicals, especially because they could be used in the manufacture of controlled substances. And we also may use the terms active ingredient as well as inactive ingredient. Active ingredient referring to that compound, for example, in a tablet, that may cause the stimulant effect or the depressant effect. Inactive ingredient referring to all those components that will keep that tablet together, like the tablet binders and the sugars, that in fact don't have any pharmacological effect. Jurisdictional differences are very important because there are laboratories and analysis that are being done at the different stages, different jurisdictions. Federal laws may vary from state law as well as county and tribal laws. And these differences will directly influence not only the scope and extent of analysis, but also the turnaround time for results. And in fact, it would also affect the contents of the laboratory report. So a laboratory report that has been requested from a county laboratory or laboratory analysis that has been requested may look very different in the contents of the report as a laboratory report that's received from a federal jurisdictional laboratory because the legal requirements are different, and therefore that defines the scope and extent of analysis. And just to give you an example, there are many jurisdictions where, for example, the salt form of the drug is not important. For example, in the case of methamphetamine, a laboratory may work in a jurisdiction where determining that in fact the drug is methamphetamine hydrochloride may not be relevant. Only the identification of methamphetamine as the core form of the drug is what's relevant in that jurisdiction. Therefore, a laboratory will not perform additional analysis to identify further the salt form of that drug. There's a very important example, and one we often encounter at the federal level, and it had to do with the optical isomers of a drug. And methamphetamine is the typical case that we use to exemplify that. There are, in fact, two versions of the methamphetamine molecule. What we, in layman terms, may refer to the left-handed portion as well as the right-handed portion. Now, both of these forms of methamphetamine are controlled under federal law. But due to sentencing considerations, the laboratory may, in fact, need to perform additional analysis to identify if the right form of the drug or the left-hand form of the drug is the one present. Nowadays, we encounter a lot of analogs and positional isomers. Right here on the slide, you see the structure of 4-fluoroamphetamine. This drug may exist in different forms, and the analyst may need to identify if that fluorine, identified as an F on the slide, may be in position 2, position 3, or position 4. If the law on that jurisdiction in fact requires the laboratory to identify that specific drug. Now, the law might have been written so that any type of fluoroamphetamine is controlled. So in that case, the laboratory can stop their analysis there, and there's no need to go further. Purity analysis may also be the type of analysis that may not be needed in a lot of jurisdictions. Even at the federal level, is not needed because purity may or may not be considered for all types of drugs done under sentencing considerations. But there may be jurisdictions where specific sentencing may apply if it's either a substance containing versus the actual amount of the substance. Because, for example, 500 grams of material containing cocaine may not be looked at and sentenced the same way as 500 grams of material that only contain 20% of cocaine. In that case, the jurisdiction may call for the sentencing of the specific 100 grams of cocaine, which is equivalent to the 20% of the 500 grams. Analog considerations. In this day, when every week we get to learn about a different analog of fentanyl, a lot of jurisdictions had decided to go and control a class of methamphetamine analog compounds. Other jurisdictions have gone on to list or control specific compounds of the fentanyl family. So those legal considerations will result in different extent of analysis. And obviously, there's also the encountering of listed chemicals that may in fact lead or may need to be identified in order to prove or disprove if the particular individual was participating on a clandestine manufacturing process. So all these jurisdictional differences will in fact determine the extent of analysis, how many tests would an analyst must do in a laboratory that's accredited and with validated methods in order to prove or disprove the presence of a substance. The laboratory submission process varies from jurisdiction to jurisdiction, but in general, it almost in every case is done in person by a law enforcement officer or the particular case agent, and this also occurs in the federal jurisdiction. Submission of laboratory evidence may also be done by mail, like registered mail, especially if the evidence comes from locations but where it may not be easy for the case agent or law enforcement officer to personally visit the laboratory to deliver the evidence. But there are some things that are absolutely essential during the laboratory submission process because they ensure chain of custody, and that should be a chain of custody documentation. Everything that comes into the laboratory should always be accompanied by a piece of paper that specifies what the evidence was about, where it was obtained, to ensure that the correct item is in fact being analyzed. Documentation also ensures that tampering is avoided, and preservation of the evidence is very important from the moment in which it was seized until the moment it is disposed by the laboratory. We have different types of samples that come into the laboratory. Not everything is a white powder, and powders can come in different colors. We could also have crystalline materials as well as gummy, paste, and tart-like materials that are very hard to handle. Tablets and capsules may come from a single unit into the thousands of submissions. Liquids also get routinely analyzed by the laboratory, as well as plant materials, edibles, and paper and paraphernalia that may be found at a crime scene. And in general, the steps of analysis can be summarized into 4 sections. The first test that is done is usually a weighing of the evidence, followed by a sampling procedure, which is then followed by analysis and concluded then by the formation and drafting of a laboratory report. So what is a Netway determination? Well, even though this may not sound very scientific or chemical at all, this is in fact the very first test that's formed in the laboratory by any forensic or CLIC analyst. And this is, in fact, when we refer to Netway, this is the actual weight of the drug materials. It should not include any wrappings, any packaging, any boxes or containers. Some jurisdictions, again, will require the determination of the total weight of the evidence. However, depending on the status in some specific jurisdictions, a partial weight of that evidence may in fact be enough. So it's important for attorneys also to understand if the weight that is being reported was the total weight of evidence or just a partial weight because of jurisdictional factors. The Netway, depending on the type of exhibit that's being submitted to the laboratory, could be a direct way or also a way that has been obtained by extrapolation. Very few times, especially with the load that laboratories have these days, if there's a submission of 10,000 tablets or approximately 10,000 tablets, very few times would the analyst actually sit down and count 10,000 tablets. First of all, there's going to be a lot of error associated with that. So in a lot of those cases, the laboratory should have a procedure to do a proper and reliable extrapolation of that evidence, for example, to determine the extrapolated number of units or tablets or pills that may be present in an exhibit. Now, there's also something that has become more often, and as attorneys you may see in laboratory reports, and it's something called uncertainty. And just to make it simple, you know, what we're referring is to that number that is right to the right of that plus or minus sign in the last 2 of these bullets colored in purple. And Netway uncertainty gives you an idea of the quality of the measurement that has been made. If I tell you that the evidence weighed about a pound, or I tell you the evidence was 450 grams, 448.2 grams, 450.2 plus or minus 1.2, or 450.36 grams plus or minus 0.12, I am in fact providing you similar information, just to the different degrees of quality on that result. Could this result be deemed different? Well, all depends again on the jurisdiction that you have, but the more important part is that those results, and the reason that uncertainty is added to those results is because results are influenced not only by the equipment that is used, but also by the calibration that instrument, and in this case this would be a balance or a scale, by the calibration that equipment has undergone, the routine performance verification that this instrument undergoes in the laboratory, and that's usually done with properly with reference weights. The result of a Netway measurement are also influenced by the procedure, the way and the manner that an analyst might have performed that weight, as well influenced by environmental conditions. A laboratory that's in fact located on the ground level of a building may have specific procedures to keep their balances working properly versus a laboratory that's located on the 20th floor of a building. That latter laboratory needs to take into account the vibrations that those balances undergo and how those vibrations could in fact affect the Netway and the uncertainty associated with those measurements. But that extra number does provide you with the quality of the measurement. It in fact will let you know if the analyst or drug analyst used a advanced type of instrument, a calibrated instrument, or if it used an instrument that may or may not be relied on. Now, the second step after the evidence had been weighed, after entering the laboratories, is for CLIC analysts to employ a sampling procedure. And every laboratory should have a sampling policy in place. Sampling is necessary because not all items are analyzed on every scenario. It's absolutely not practical or feasible to in fact analyze and test every single item that comes in the laboratory. Now, the sampling policy that a laboratory has may be practical and must be effective. In all drug analysts or analysts in general should be trained into follow it properly so that reliable conclusions can be generated. And this is very important because the conclusions that are reported and documented in that laboratory report will in fact be affected by the sampling procedure. And similar to the other factors that I had mentioned before, these sampling procedures may also depend on the jurisdiction.
So I'm going to interrupt you for a second. There's a lot to unpack here. And there is a question from the audience that asks, with regards to sampling, you say it's not always possible to analyze all of the exhibits that are submitted. The chat person asks, well, why don't you do all possible testing on each drug, even if the jurisdiction does not require it? Is that simply a resource management issue?
It's many issues. One of them is the resource management. Another very important part of it that a lot of the times don't get discussed is exposure. To protect our analysts to the exposure of large amounts of these materials. So we train them on doing appropriate sampling procedures. And sampling happens everywhere. Not everything that comes out of the manufacturing facility of some food company gets tested either. So we use exactly the same procedures so that we can have the results that are reliable and we can have results on time for the attorneys that will need them.
Thank you. Thanks.
Very important question, and it's very important to understand what is it that we don't do that. So, and in order to reach, and again, it gets influenced by the jurisdictional different jurisdictions that the laboratory may be in. So in general, sampling procedures could be divided into two kinds: statistically based procedures and non-statistically based procedures. The statistically based procedures will allow for an inference to be made on the population without having to test all the items. Statistically based procedures are practical, they're well-founded from statistical principles. Again, it reduces the exposure, but it does require a laboratory to have implemented random procedures for the selection of those items. And these procedures are very similar to anybody that wants to conduct a survey, for example, and they want to get a good representation of the opinion of a specific population regarding an issue. They're going to try to do a random selection of those items and of those individuals so that the conclusions can be extrapolated to a larger population. So we follow exactly similar principles for that. Now, on some jurisdictions, the sampling may be non-statistical, where not all items are tested. They don't need to be tested. They're not needed in order to produce a fast turnaround result. And one thing to remember is that if this is the type of procedure that is used for sampling, then an analyst or in a laboratory cannot make an inference on the entire population. If an analyst only tests one tablet out of 100, then the laboratory report should read that only one tablet was analyzed. The different testings and general procedures that are done in a laboratory, such as Netway Determination, identification, or the actual purity of a controlled substance, they can all be done in two different ways. Either you can test part of it, or you can test the entirety. And it's very important for attorneys and defendants and those customers and the judge and the court and members of the jury to also understand that a laboratory may have procedures to do the same thing in different ways. However, they should also understand and be able to communicate the consequences that doing one procedure versus the other will have on the results of analysis. Chemical analysis in general can be performed using many different tests. Some of those tests may be instrumental, may be use of a particular type of machine or scientific instrument. Others may not need the use of a particular instrumentation. Chemical analysis may encompass qualitative as well as quantitative analysis, and all these analyses should be put together in what we call an analytical scheme, which is the entire procedure that would generate the results that will make the analyst able to form a conclusion. Instrumental tests, as some of you may be familiar with, may be separation tests such as gas chromatography and liquid chromatography. These instrumental tests perform the test of separating the compounds. If you have multiple analytes in a mixture, this is the type of instrumentation that will tell you how many of these compounds you have. Mass spectrometry, as well as the different spectroscopy techniques that are listed, these are slightly more discriminating techniques, because not only they can tell you the compounds after they're being separated, they're going to give you, in many cases, something that we could describe as a chemical fingerprint of that particular compound. All these techniques have their limitations, and the analyst using their techniques should be able to communicate those limitations to the customer and the people receiving the results. Non-instrumental tests, a lot of these tests have been available for many, many years. Color tests are used not only in the laboratory, but also by law enforcement officers. Microcrystalline tests are still used in many laboratories. Some of these tests have been around for decades, but there's still, some of them are very, very specific and quite reliable for the identification of some particular compounds. And then we also have the technique of thin layer chromatography that is often used by laboratories. It's another separation technique that doesn't necessarily require all the convoluted and fancy instrumentation like a gas chromatography instrument or a liquid chromatography instrument, but it still does the job of separating the compounds. Now, for qualitative analysis, what we're trying to do is identify the analyte that is present. And that could be done either in a presumptive way or a confirmatory way. And just to remind everybody, not because a machine or an instrument is being used, the result that's being obtained from that machine may still be a non-confirmatory result. It may just be a presumptive result. And on the same token, most non-instrumental tests are considered presumptive. And what do we mean by presumptive analysis? And a lot of laboratories may call this screening. And these tests just give us an indication of what could be present in the sample. They don't tell us with absolute certainty that a compound is present. On the other side, confirmatory analysis, these are the techniques that in fact would be possible to give us, depending on the conditions of the sample, that chemical fingerprint, so we can make the conclusion and report with a high degree of reliability on our results. And obviously the laboratory not only should employ this method, but should only employ them after this method has been documented to be valid and to be validly executed by the members of that laboratory. Quantitative analysis goes a little bit further, because now quantitative analysis, we already know what we have. Now we want to know how much is there of it. Just like we want to know there's 20% juice in a can of juice that we purchase, and those methods will also need to undergo validation in the laboratory before being used for casework. Now, all these multiple analyses should be combined in the laboratory in the form of an analytical scheme, which is not only but a combination of all those techniques that will be applicable to answer the question that is being asked in the particular jurisdiction. And again, all these should be using validated methods under quality assurance and quality control conditions, and most of those that are in fact ongoing in an accredited laboratory. There are organizations such as the Scientific Working Group for the Analysis of Seized Drugs that have put out minimum standards for identification. A lot of these recommendations have also been taken through standard development organizations. And in specific, ASTM document E2329 has established minimum recommendations for the analysis of seized drugs. And those minimum recommendations are as follows. It states that 2 different tests should be done on each piece of evidence, and if a category A test is done, then it must be accompanied by another category test, either under category A, B, or C. And if the laboratory does not have a category A available, or it cannot perform a category A, then 3 tests must be done on each piece of evidence that's entered into the laboratory. And this may, in fact, also mean 2 or 3 different tests on multiple tablets, if that has been the case submitted to the laboratory. Now, just to give you a general summary of what category A's, B's, and C's are defined based on the Scientific Working Group for the Analysis of Seized Drugs, these are how the techniques are classified. With category A techniques such as different spectroscopy techniques as well as mass spectrometry, and these have the highest selectivity because they're the ones that are capable to give us that chemical fingerprint. category B techniques, we put here a lot of the separation techniques. Those may give us very reliable information, but that are missing some of that structural information. And category C are the lowest selectivity, but these are very good tests for initial testing, for screening, as well as for corroboration when a category A or B are also used. And this is an example of a combination of multiple techniques that a laboratory may employ to identify the substance methamphetamine. So let's say this is a crystalline material that was submitted to the laboratory, and the laboratory did perform as an initial test an infrared spectroscopy. So that would be a category A. However, the sample is a mixture, so they obtain a mixed result that was deemed inconclusive. The laboratory may perform a color test, and that color test, even though it's a category C, it still gives an indication that the sample may in fact contain methamphetamine, even though it's mixed in with other components. Even though the analyst has already performed an A and a C, because the results are not conclusive, they should not stop there. They should continue on to maybe add in a category A or a category B in the form of gas chromatography, so that they can achieve to a conclusive result regarding the presence of that controlled substance. So the end of the laboratory analysis will end with the preparation of the laboratory report, what it's sent back to the law enforcement officer or the case agents with the information. And there are some essentials for a laboratory report to contain, and it should contain the name of the laboratory where the analysis was performed, the dates in which the evidence was received, the types of analysis were performed. There are laboratory reports that in fact require for the specific techniques to be listed. The submitting agency, any evidence, unique identifying information that the laboratory labeled that evidence with. Obviously, the results and conclusions of analysis, and that should include the weight as well as the main substance and even additional substances present, the techniques used, and the analyst name and signature, either in a manual form or an electronic signature. And this is maybe a little bit hard to see, but this is an example of laboratory reports. And this is available through the Scientific Working Group for the Analysis of Seized Drugs. And this is not in the main document recommendations from the scientific group, but this is part of one of the supplemental documents that we provide. This is in fact supplemental document number 5 or SD5. And in that document, you can find 2 examples of the contents that we believe should be in a laboratory report that has been generated after analysis from a seized drug laboratory. So you can go to the website and visit a couple of the examples as well as the recommendations. And obviously, the quality assurance process in the laboratory should conclude with evidence preservation. There should also be policies and procedures to ensure the preservation of that evidence, the appropriate storage of the evidence, either if it's going to be stored in the laboratory or if it's going to be returned to the submitting agency. And why is this important? Because there may be future reanalysis of the evidence. And that future reanalysis may be done either by the prosecution or by the defense side in a specific case. And once the case is either dismissed or stipulated with or adjudicated, then also procedures for final disposition of the evidence. There are many seized drugs standards, and just to follow on the subject of the webinar today, there are a lot of documents that are available to the general public. The SWGDRUG recommendations and supplemental documents that I already mentioned. Through the SWGDRUG website, there's also links to many resources throughout the world, forensic resources, ASTM standards that are also available that were produced either by the Scientific Working Group or by other organizations. And we also have the Organization of Scientific Area Committee standards. The SWGDRUG recommendations are divided into general parts, and they pertain to education and training, methods of analysis, as well as quality assurance documents, quality assurance policies and procedures that we believe a laboratory should have in place. And there's also the supplemental documents that are available through the website. There are supplemental documents on validation of analytical methods, as well as multiple examples on measurement uncertainty, how to construct an analytical scheme, and SD5, which was the reporting example supplemental document that I just showed you a part of. A lot of these recommendations have been converted into standard development organization documents, and these are some of the documents that can be found through ASTM International. Two of these documents are marked because they are also documents that have been taken through the organizational scientific area committees and are now they're populating what we know as the OSAC registry, and they're available again to the public, and they pertain to the identification of seized drugs, those minimum requirements, as well as the sampling of seized drugs for qualitative and quantitative analysis. And these are some of the resources that you can visit to obtain a little bit more information, not only of these documents, but also in current work items that the subcommittees and the scientific working group are busy working on. There's also a forensic site that I wanted to point out. It's called Forensic Science Simplified, and it has information about a lot of forensic disciplines, and in specific, it also has a section for controlled substances where there's a lot of information, and it starts very general for seized drug, not only practitioners but also law enforcement officers, as well as attorneys, and there's a very good place to maybe start learning a little bit more of what the seized drug discipline actually entails and how analysis are to be done.
Well, thank you very much for a very comprehensive overview of the analysis of seized drugs. We do have one more question from the chat room, and that is, are there any testing methods other than chemical analyses for testing seized drugs?
Chemical analysis, well, chemical analysis from the point of view of doing tests in the laboratory and performing reactions. The testing of the drugs via instrumentation, some people may perceive that maybe as non-chemical. I guess I'm not quite sure what they refer by other than chemical analysis on the testing. So maybe we can get some clarification on the question.
Yeah. And you mentioned that 2329, it's really important that we have these consensus-based standards on the registry and widely accepted by a broader community than even ASTM and the SWGDRUG community. But given the nature, the very dynamic nature of the drugs that are being encountered out in the field, how do the laboratory scientists just keep up with the analytical methods that are required to identify these new, seemingly new drugs every week?
Well, the reality is that a lot of the instrumentation that the laboratories are already equipped with could in fact be used, or new methods can be developed. And a lot of those new developments come from interaction, for example, with academia and professors and universities like you that are performing research that then can be adapted for the laboratories. But the reality is that a lot of the instrumentation that we do have is capable of analyzing high levels, low levels, and if they're not capable at the moment, there may be methods that could be, with the help of research and development, also developed.
Yeah. And as you say, 2329 addresses the minimum analyses that should be done, and there might be an occasion where you need to do additional testing.
Absolutely. In fact, most of the time, the laboratory, because of their jurisdiction that they are on, must also perform additional analysis. And just to point out that E2329 also came from the SWGDRUG recommendations, which are in fact universally adopted by many laboratories throughout the world. So it's a minimum that a lot of drug practitioners have agreed on and have demanded of each other from that point of view in order to have a minimum result, high quality, reliable, reproducible result. Yeah.
Thank you very much.
You're welcome.
When dealing with drug-related cases, a broad range of considerations such as the prevailing case law, discovery, interpreting laboratory report findings, and expert witness testimony is critical to providing competent legal counsel. Alec, based on your considerable legal experience, what information do you feel is most important for attorneys to consider when dealing with cases that involved seized drug evidence?
Well, thank you so much, and thank you for having me today and coming behind Dr. Cruz. That's a lot of information to digest. But I think the importance that we're trying to seek here, the drugs that have been seized by law enforcement, properly preserved, stored in evidence, it makes a difference in the end what type of drug you have. We talked about the jurisdiction, whether it's a state prosecution or federal prosecution. My practice has been state, now it's been largely federal, but I still stay abreast of state. Depending upon the type of drug that has been seized, the weights, that can affect the type of sentence the person is looking at, statutory, and certainly in the federal system, you're looking at, it may impact the federal sentencing guideline depending upon the type of drug that has been seized in this particular case. So all of this leads to, we want to make sure we get it right, whether you're a prosecutor, whether or not you're a defense attorney, we want to make sure we get it right. So now in this case, in my materials, I like to start with the Sixth Amendment right provides in all criminal cases, the accused shall enjoy the right to have the assistance of counsel. So just like a defendant has a right to counsel, the government, the state has a right to zealous representation by the prosecutor as well, and making sure people who violate the law are properly prosecuted. So it goes both ways, and that's what you're going to see during the course of my presentation. Now we need to make sure that when we're being zealous, we're not overly zealous, and you find yourself on a bar complaint of some sort. So we want to keep these things in mind. But the point I'm making here is that you want to be zealous for both sides, prosecution and defense. And then at the end of the day, you certainly want to make sure that the drug at issue is in fact properly what it has been reported to be. It's been properly tested in a credible lab, credible testing procedures, as Dr. Rodriguez-Cruz has pointed out. And these are the things as an attorney you want to make sure on the prosecution side as well as on the defense side, these procedures are properly being followed. So at the end of the day, the person in this great country in which we live, they had their day in court. The evidence shows or it does not show their guilt or innocence in this case. So what I'd like to point out, and one of the things I'm in my materials, and when I say that we want to make sure we get this right in doing the analysis, the drugs, and things of that nature, I like to point out what the Innocence Project has indicated. The work of the Innocence Project has led to the freeing of more than 350 wrongly convicted people based on DNA, including 20 who spent time on death row, and the finding of 150 real perpetrators. You may have saw in the news on last week another individual was exonerated and freed after so many years in prison. So I think on both sides, prosecution, you want to make sure you're doing your work, testing the evidence, making sure it is correct in all aspects. And on the defense side, you're doing your investigation as well. When we look at, and I'm looking at the federal rules as our example for this presentation, federal rules of criminal procedure. So several areas I'm going to cover, discovery, arraignment, discovery, and some other legal issues as well. But when we look at Federal Rules of Criminal Procedure 10, a person in federal court normally is indicted and charged with a federal offense. I'm not going to get into the very details or the minutia of, or the minute details of a person being prosecuted in federal court. But generally, just for the sake of clarity, generally a person is going to be arrested on a indictment in federal court. So under the rule, you can waive your right to be present at the hearing and enter a plea of not guilty. And then at that same hearing, if it's in person, you decide to come to court, then you're going to enter a plea of not guilty. The judge is going to ask you, are you going to participate in discovery? I normally say yes. I don't know why someone would ever elect not to participate in discovery. If you elect not to, then you're not going to see the government or the state or prosecution's evidence. I've only seen that in my 20 years of practicing maybe once or twice, and I just kind of stared at someone doing that. But generally, I'm going to, or all the time, I'm going to ask to participate in discovery. So now, once you indicate you're going to participate in discovery, the judge is going to ask the prosecutor, does the government in federal court, do you request reciprocal discovery? That imposes upon both sides an obligation to comply with the discovery requirements under Federal Rules of Criminal Procedure, Rule 16. There's a misnomer for those who do not practice in federal court. There is no discovery in federal court. Well, that's not true, because if you look at Federal Rules of Criminal Procedure 16, there is discovery requirements, and discovery is provided for. You're not going to get a buffet of discovery as you will find in state court depositions and things of that nature, but there is some discovery. So at the arraignment, I enter a plea of not guilty. We're going to participate in a discovery process. The government files its answer to the discovery request, and as I've indicated, it's asking for reciprocal discovery for those things that the defense attorney will come across. It's in your materials, the discovery rule 16. The major part I really want to focus on as it relates to what Dr. Rodriguez-Cruz in this presentation addresses is the drug evidence and laboratory testing. So when you go to Rule 16, the one I'm focusing on, look at Rule sub E. Upon a defendant's request, the government must permit the defendant to inspect and to copy or photograph books and papers, documents, data, photographs, tangible objects, buildings, et cetera, et cetera. So these are a lot of things that Dr. Rodriguez-Cruz was speaking of. So in the discovery, when it's a drug case, keep in mind that when a defendant has been arrested in the streets or whatever the case may be, and there's drugs involved, the arresting officer or agency, they're going to test a drug in the field. We call it a NIC test, where a sample is dropped in a tube or a bag, and if it turns a certain color, and Dr. Rodriguez-Cruz spoke about this, and if it turns a certain color indicating that it is illicit substance or illegal substance, then that's going to constitute the person being arrested. Now, to the defense attorney, that means nothing, because all that results in is the person being arrested. And practitioners, we're familiar with the case Illinois versus Gates. On a scale of A to F, D- is passing for an arrest. So that's the arrest. The drugs are bagged and seized. Prosecutors, you know that all you need to do is call the agent, the arresting officer, the detective, the lab. They can answer all of your questions. And I do recommend that you stay on top of your case so you know your case backwards and forth. Because if it has holes in it, defense attorneys are going to be attacking it severely. For a defense attorney, we want to see the lab report, and Dr. Rodriguez-Cruz spoke about the lab report that is ultimately generated after the testing process has taken place. But when you look at Rule 16E, it talks about the documents and objects. So you want to make the request, and you want to get in there and look at why do you need this evidence? And so in the materials also is pretrial motion practice. You have to investigate your case and file the necessary motions, because as I've already indicated at the outset, the client and the government as well, or the prosecution, is entitled to zealous representation. So on the defense side, why do you need to see the evidence? You file your motions and things of that nature. You want to inspect the lab. You have the lab report. These are things you want to examine. You want to hire your own expert, because the weight of the drug can make a difference. One, is it an illicit drug? The weight can make a difference. For example, now with the FSA having been passed several years ago, Fair Sentencing Act, I'm going to use crack cocaine, for example. Before the Fair Sentencing Act years ago, 50 grams of crack cocaine base would get a person 10 years minimum up to life in prison. Now, with the Fair Sentencing Act, that requires 280 grams of crack to trigger the 10 to life penalty, or 28 grams of crack. Now you're in the 5 to 40 range. Years ago, it used to be 5 grams of crack or more, but less than 50 grams would trigger the 5 to 40 range. So the weight makes a difference in the case. If it's methamphetamine, and let's say, I'll go back to the crack cocaine example. Let's say the crack cocaine, under today's standards, 28 grams for the 5 to 40 statutory penalty. Let's say the crack cocaine came in at 27 grams. Well, that doesn't trigger the 5 to 40 penalty. Let's say it came in at 279 grams. Well, the person is not the 10 to life. The person is in the 5 to 40 range. And so now you save that person 5 years minimum off of the minimum mandatory. So the weight of the drugs makes a difference. And by the way, practitioners, state and prosecutors, as well as defense attorneys, we do not round up when we do weights. So if someone had 27.99 grams, oh, okay, well, that's 28 grams. No, it's not. It's 27.99 grams. And therefore, using the crack example, that person is not looking at a minimum 5 years in prison. They're looking at max 20, but certainly not a minimum mandatory sentence. So be familiar with the rule here, E, and then I also, F, reports and examination tests. Dr. Rodriguez-Cruz was telling you about these things. You have the lab report at your disposal. The government, the prosecution has turned this over to you under their obligations under the rule of discovery to you, the findings of the lab testing. And the rule clearly says here, upon a defendant's request, the government must permit a defendant to inspect and to copy photograph results or reports of any physical or mental examination and of any scientific test or experiment. Practitioners, when you're filing your motions, pretrial motions, cite the rule so the judge is clearly on notice, as well as the defense attorney or prosecution, on what relief you're seeking and why you're entitled to it. Those who do not practice in federal court on a regular basis, please do not file a shotgun motion, that being notice of discovery, notice of appearance, and just standard motions that you would file in state court, because if you file such a motion or motions in federal court, those motions will be struck, and the judge will let you know about it. We don't do that over here. Follow the discovery order, and there's a copy in the materials or will be posted as part of this presentation today. I've included a sample of a general discovery order that's used in federal court. And look at the other requirements of the rule as well under F. So E, F, and then we also go to G, expert witness. Again, at the defendant's request, government must give, not discretionary, must give to the defendant a written summary of any testimony the government intends to use under your expert rules. You get into your Daubert test and challenges 702, 703. I would even add 704, but the rule says 705, but the federal rules of evidence during its case in chief at when? Trial. Okay, so these are the requests you're making of the government. You're meeting with your client. You're going over these things. Prosecutors, you're on top of the rules, knowing that if a defense attorney makes a certain request, it's not permitted by the rule, it's not going to aid the jury at all, then you're going to file your response saying that it's not permitted under the rule and it's not going to aid the jury in making its determinations. Let's go over some points. It's in your materials, points that I want to highlight to all of us. So I've indicated at the arraignment, you've indicated a plea of not guilty. Many people, non-lawyers, say, well, why did that person go to court and plead not guilty? Well, maybe the statute of limitations ran. Maybe there's been a violation of the Fourth Amendment or Fifth Amendment or Sixth Amendment violation, and these are proper mechanisms or issues to be brought to the court's attention. So you always enter a plea of not guilty until you've had a chance to meet with the client, review the evidence in the case. Here's some points I want to look at in federal court. As I've indicated, what issue a discovery order. I suggest to both prosecutors and defense, prosecutors as well. Now, prosecutors are at an advantage because they have a detective. In federal court, we call it a case agent on the case. They have local agents as well, the agencies they're working with, so they can make a call. Defense attorneys have to be more aggressive in terms of investigating the case. But the point I'm making here is number two, review your case and discovery thoroughly and know your case in and out. Investigate your case. What is your theory of the case, prosecution or defense? I like to go and review my crime scenes a lot of times. review the case, the discovery that's been provided, and the theory of defense with the client, or theory of prosecution as well. Listen to the client. Defense attorneys listen to the client's version of what happened. He was there, or in this day and age in which we're living, she was there. So you were not. And so always listen. Review the evidence that you were not provided with in discovery. Now, what I mean by that, let's say you have the written report, you have the lab report, but let's say there are photographs of the evidence itself that you may not have received in discovery, but the agent has custody of it. It will say in your discovery letter, state or federal prosecution, contact the agent or whoever has the evidence, and you can go out and review it for yourself. So I like to take advantage of those things, and I think that is critical for us to do, especially for this presentation, where the issue, it's an issue of whether or not, or there are problems with the evidence, is that the drug that is in question. Years ago, sometime individuals that were on the street selling drugs, they would sell fake drugs just to get money from the person that was that had money. So let's say a person has a gold medal flower or a Pillsbury, take your preference, and they put this up to be like drugs, and they take off with it. Well, you certainly want that drug to be tested, and if it's fake, then it's certainly not a crime. Now, it may be a crime to sell something fictitious, but in terms of it being an actual drug, that is going to be critical to testing of it. So that's why you certainly want to go and review the evidence, and you certainly want to test the evidence that the government has seized.
So I'm going to stop you here because we do have a question from the chat, but additionally I have a question or a comment that even though Dr. Cruz has talked about the consensus standards addressing the analyses of seized drugs in the laboratory,
yes, sir,
there are additional standards that address what happens at the crime scene.
Okay.
So equally important, you brought this up about chain of custody,
yes, sir,
packaging, and proper seizure. So there are units of the OSAC that are devoted to this.
Yes, and that is so critical because the way the evidence was collected will be attacked, and that is going to be in the written report. What happened once the person was arrested? How was the evidence collected? Did you cordon off? Did the officer cordon off, or the agency cordon off the area? Because if the evidence is contaminated, the lab, as Dr. Rodriguez-Cruz pointed out, can only test what is being given. And that's all the scientist is looking for. It's going to test what it was given, how it was collected. If it was contaminated, you had boots on the ground in the crime scene, and it was contaminated, it's going to affect the results. So we've heard the familiar adage, garbage in means garbage out, and certainly prosecutors should be aware of this. That's going to affect their case, and defense attorneys are certainly looking at punching holes into these type of things. So it's so critical for the preservation and proper handling and collection of evidence and storage.
Everybody participating. And just to point out, I mean, we have been in scenarios where the evidence, we do our part of the testing, we have absolutely no knowledge of what has happened to that sample, how it was obtained, who obtained it. And a lot of the times they cannot ask, or we cannot provide what we don't know.
Right.
And it's very important because it affects the conclusions.
Right. And let me give you an example. I had a case several years ago where an officer, there was a shooting, drug deal, run takes place, and the individual that's running has a gun on him. Well, everything's escalated at this point, and the officer had to end up shooting at the gentleman. He did not die, actually didn't get shot. But then the officer turns around and starts going back and collecting his evidence. Now that's improper because the officer has been involved in the shooting. He should be out of the crime scene. Is he contaminating the evidence? And one of his fellow officers, hey, stop what you're doing and step away. And so that's a situation where you want the integrity of the evidence and proper handling of it to be intact. Okay. 8, test the evidence that the government says it is in the case that implicates your client. Example, fingerprints, drugs, DNA, etc. So from a defense side, you get DNA, you get fingerprints. So now why does the evidence have to be what the government or prosecution says it is, state says it is. And when you get these things, sometimes you have a heart attack. Oh my goodness, this is bad. Well, let's stop, take a breath, let's look at it, let's analyze it. Maybe it's not what it purports to be. Maybe it comes from a bad lab. Maybe the person who tested it has some issues and proper testing was not done, and you want to educate yourself on these things, and that's what I also put on my in the materials. From a prosecution, you want to be on top of this. Hey, the evidence is solid. I've got a great lab. I got a great chemist who tested it. Chain of custody is intact. The evidence was properly preserved, and it's A through Z is properly documented. No attacks can be launched from the defense that will be successful. Have your expert test the government's findings, as I've indicated in point 9. 10, if an expert is going to be used in the litigation, pretrial or trial, then hire your own expert. I believe a client, should, as on the defense side, should have his day in court. So you hire your expert if that's necessary and show the client, hey, this is what it says it is. It verifies or contradicts the findings of the prosecution in the case. If an expert is going to be used in trial, as I've indicated, hire your own. This is what we come to know, or like to say in law, battle of the experts. Why does the government expert have to be right? Investigate the expert. Going to testify at trial, you have their statement. What is their training, level of education, documents, written reports, academies, and the discipline. All these things will be proper for cross-examination. And for the prosecutor, you want to make sure the person who's testifying for you is a clean presentation. Educate or refamiliarize yourself on the subject matter. DNA, if you're doing any type of practice, state or federal, you're going to come across this. So there are books here. I know Carol Henderson and was my professor in law school, so she has a book out with other colleagues. That's a book I keep handy in my collection, and it covers a variety of scientific testing. So you can educate yourself on these things, and you're going to need to know these. And then answer all of the client's questions. If you don't know the answer, then research and research the question and get an answer. And the same applies also for the prosecution. I'm going to go into pretrial motions. I think whether you're doing state practice or federal practice, pretrial motion practice is so important. We've touched on rules E, F, and G of Rule 16. Here I take out for our review 16A1EI. Upon a defendant's request, the government must, as we've covered. And so the question is going to become, why do you need this evidence when you're arguing your motion? Judge, it's material to my defense. This is my theory of the case. It's incomplete. We don't have this information. And so therefore you need to make a colorable showing of why you need the relief you're requesting in your motion. Here are some things you want to be careful of when you're dealing with labs. You're not just taking everything that the government or state prosecution is giving you. When there's an issue that you need to investigate, you have questions about the lab. When you review your case, these are some things that I wanted to.
So there is a question in the chat about this too, and I'll ask Sandra to answer if she can. How does an attorney assess whether a laboratory is producing reliable results?
Okay, so.
Maybe I'll get both of you to answer.
Yes.
Okay,
you
all right.
Go first. You can go first.
I want to hear his perspective first.
Chivalry's not dead. So, most of your communities, prosecution and defense, they have databases. They're experts across the country. That's a well-known fact. In the legal community, amongst attorneys. So you'll have experts in the databases for prosecution and defense. So you can call an expert, and a lot of these experts, either on the prosecution or even on the defense side, they're world-renowned and certainly known nationally throughout the United States. So if you call them, they can tell you about a lab. Hey, I have a case here. This drug was analyzed out of the Texas Instruments lab in South Texas or something like that. And they can tell you, whoa, wait a minute, is that the lab? And they'll have all type of information, and they can put you in contact with other individuals who have known that this lab is known to have bad testing. Googling, just asking a question, and there are reports out there that you can do searches on, and that can lead you to a string of information to find out about their credibility.
That's one way. You have.
Well, another way, and I just wanted to point out that because of the interest of around the world through forensic sciences in general, because of that, and cases that have come forward where there have been issues, maybe not a lot of issues with entire laboratories, but with particular analysts that have come into problems and have been dismissed. A lot of laboratories have also put their policies and procedures online. So it is definitely a piece of information that now you're welcome, and it's open. You can go and see, okay, when a laboratory receives a piece of evidence, I have this policy and procedure, this is what they're supposed to be doing. So that's your questioning. So there you go. It's like, okay, so I'm going to check if this particular analyst that signed off for this particular laboratory report in fact followed and can explain what this means and what type of testing. And if I can almost assure you, if the analysts have followed proper procedures, they'll be eager to talk to you about it.
I agree.
Because we don't get to interact and explain what we do and how we do it to a lot of the general public. And if the procedures are followed, and it's been also good for the laboratories that their policies and procedures are out there too, because now we know we're going to held accountable.
That's right.
Against that.
That's right.
Well, I'll add to that. So how do you know if a laboratory is producing reliable results? Are they accredited?
Right.
Sandra said that not all laboratories are accredited because it's a volunteer process, but more than 90% or so are. If the laboratory is not accredited, then that might be a red flag.
Right.
As Sandra says, are they uploading their procedures, and do those procedures follow the OSAC recommendations of these consensus-based, that the community says we should be using these methods, these standards?
Yeah, and I agree. And accreditation is so critical. I can't think of a reason why a law enforcement agency would not be using an accredited agency, because that's a severe attack. When you go to any type of litigation, especially at trial. Davis versus Alaska provides that wide cross-examination should be given on government star witness. So if a lab or a scientist saying, hey, this is what I did, but they have a sketchy background, the lab has a sketchy background, that's fuel for fodder all day long. So these are things that we need to be aware of. But again, ask, research, and there are cases out there, Nexus, or your Lexis research, as well as Westlaw. There are cases that have been litigated in court where courts have found this is what was going on out of a particular lab. So that's the research you want to be doing in preparing your case and doing a thorough investigation.
Thank you.
Discovery requests of labs, it's in the materials. Cell phones are so popular now. Cell phone extractions, making sure that was properly extracted. You've got a cell phone expert that's telling you what he or she needs in order to verify what the government or agency is reporting. Laboratory technical procedures, Dr. Rodriguez-Cruz talked about this. A good scientist, someone correct me if I'm wrong, will be eager, as she indicated, to share with you, this is what I did. And let me say this to all of us. We want to, as I said at the outset, we want to get this right. We don't want the wrong person sitting over there in prison for a long time. So let's get it right. Your scientist, your expert that you hire, and you should hire one in the right situation, if not all of the time, will tell you the methods that were provided, whether or not they adhere to the scientific community standards, as was discussed here. Evidence of custody records, we talked about that, how the evidence was seized in the case. Validation studies on D, calibration of instruments. I remember Dr. Rodriguez-Cruz talking about that. That machine has not been tested or calibrated. Well, then there's room for error. Traffic stops. Officer says you were speeding. Well, he has to provide documentation for that instrument under 316.001 Florida's traffic code, and you're certainly going to be asking for those things. So if the officer is not properly, or the person who's in charge of the testing is not properly following procedures, how can anyone say that testing and the results are valid? And I will submit to you that that's impossible. And then you have other requests here that should be made. And this is not an exhaustive list. These are just some suggestions. You can speak with your expert and they can tell you, prosecution or government, speak with your prosecution or defense rather, speak with your expert and they can tell you the things you should be asking for. You see the calibration and verification of the records. What's probably not on here is the history of the lab, any discipline or sightings by accreditation agency and accreditation records. You want to see those things. Case law, a few things I'll say about the case law. Here's a case I like to use in my pretrial motions. It talks about Brady, and we all should be familiar with that. It includes the disclosure of evidence that may be used for impeachment purposes as well, and evidence that may be used to attack the thoroughness and even the good faith of the investigation. I think that is a very powerful case. I use it all the time where appropriate in my cases. This is a case I think every practitioner should know. United States versus Jordan. Prosecutors should know it. Defense attorneys should sleep with it because the investigating agency, DEA, for example, ATF, or any other investigating agency, FBI, they've collected drugs. Prosecutor says, well, hey, I don't have it. Well, that's not sufficient because Jordan clearly says only applies to materials within the possession, custody, or control of the government. Courts have found that the possession, custody, or control of the government requirement includes materials in the hands of a government investigatory agency closely connected to the prosecutor. Recently used this case in a motion to suppress. I'm litigating in federal court now. And judge ordered the government to turn it over. I mean, the law is clear here. Again, we're getting back to not only zealous advocacy, but you want to get it right. This was a case I had Hakeem Brown. It was and this goes to the purpose of your motions to compel. Individual was said to be a gang member. I filed my motion, and in the end, he was not a gang member. And there are other examples as well of 2 other cases of evidence that we sought to obtain so we can prepare our defense. It was material to our case, as I indicated to you in our earlier under Rule 16, and that's the reason why we needed to prepare our case for defense. Chain of custody, you have the case law in your materials. I won't hit all of it, but I want to give you this information. I think prosecutors and defense attorneys, this is information you need to know. Defense attorney gets up, well, the chain of custody, well, did the witness identify the purported evidence that's being offered into evidence and say that it is the evidence that he or she collected and it is what it purports to be under Rule 901. And if it is, the objection is going to be overruled. So these are things that we need to be aware of in terms of chain of custody. Now, one of the main cases I want to point out, look at the case there at the top of this slide here, minor gaps in the chain of custody affect only the weight to be attributed to the evidence, not its admissibility. Here, I want us to notice that minor gaps. As we were talking about just a little while ago, you had the crime scene. It's been contaminated. Boots on the ground. People are all in and out of the crime scene. No gloves are used. And other contamination has taken place. And the integrity of the evidence is severely in question. These are attacks that should be lodged, and every prosecutor should demand better when evidence is collected, that the proper procedures are followed. And we've all seen in our lifetime the yellow tape that goes up. You normally say, well, someone's dead, but officers will cordon off the area to also protect the integrity of the evidence. So these are things we want to keep in mind, and I included this because we should be aware of what does the chain of custody law means, and you can respond to a prosecution or defense, but as long as the proponent of the evidence can identify the evidence is what it purports to be, the evidence will be admitted at trial. Expert testimony. In my practice, I can truly say I've rarely had to deal with these rules, but just because you rarely deal with them, that's when they're going to spring their heads, and you need to be familiar with them. So in your time, make yourself familiar with rules 702, 703, 704, and 5. I've included Daubert materials for our practice. For our discussion today. Be familiar with Fry. As I understand it, there's still some debate on whether to follow Fry or Daubert in state proceedings. But the point here with Daubert or Fry, and in this situation Daubert, you're questioning the reliability of a purported practice or testimony, and you want to make the proper challenge to the evidence. I think the predicate we should all know, state practitioners, prosecution or defense, if the evidence is not going to aid the jury, then there's no need for the expert testimony. So I think you want to keep these things in mind. If you find yourself in a Daubert, refer to the materials. I won't go through them all for the sake of time, but they're clearly listed here. And I do want to highlight this because it gets to the heart of a Daubert hearing. A witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise. Now keep in mind, and it's in the materials, that when you're making these challenges, rulings on evidence are subject to an abuse of discretion, which means that the umpire, the judge, makes the decision. He or she, the judge, is the gatekeeper on whether or not they're going to allow an expert witness to testify. More than likely, they're going to let the expert testify if they meet the predicates to testify in a case. So here, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. Now, in A, again, will help the trier of fact. If it's not going to help, the testimony is not going to help the trier of fact, then the witness is not needed. Well, Judge, we have an expert that's going to come in and say 2 + 2 is 4. Not going to happen. We already know that. We should know it. So the witness will not be allowed to testify on something like that. So just to make the point, the testimony is based on scientific facts or data. The testimony is the product of reliable principles and methods, and Dr. Rodriguez-Cruz spoke on that as well. The expert has reliably applied the principles and methods to the facts of the case. This is where you want to do the research on whoever the expert's going to be, whether it's a prosecution expert, scientific witness, or expert witness, or defense expert witness. You want to vet that person, do your background investigation of the person, and be ready to go. We have distilled from Daubert, Kumo, and Rule 702 these 3 requirements. First, the expert must be qualified to testify competently regarding the matter he or she intends to address. Now here, practitioners, we want to keep in mind that one of the main questions that you're going to be asking of the expert: how many times have you testified in court proceedings, state or federal, or you break both of them down, and have you been deemed to be an expert? Yes. How many times? And you're going to bring that out of the witness as well. Second, the expert's methodology must be reliable as determined by a Daubert inquiry. And this is where you want to get into peer review. Has it been accepted in the community as reliable, whatever method the expert is purporting to be? Third, the expert's testimony must assist the trier of fact. Here we are again, must assist the trier of fact through the application of expertise to understand the evidence or determine a fact and issue. So walk through these items here and just don't automatically lay down prosecutor or defense. Well, okay, I'll go along to get along. I'll play nice in the sandbox. The client, whether it's the state or the defendant, is entitled, as we said at the outset, to zealous representation. I do want to cover this slide here. The 11th Circuit has stated, in ascertaining the reliability of a particular scientific expert opinion, we consider, to the extent possible, 1, whether the expert's theory can be and has been tested, peer review, whether the theory has been subjected to peer review and publications. John Doe, Professor John Doe, have you written any books, periodicals? Are you a member of any agencies, groups, professional associations? Have you ever been disciplined of any kind? Prosecutors, you should not be using someone who has baggage on them. Likewise, same answer or same statement to the defense attorney. Why would you use someone who has baggage on them? If a lab is a bad lab, that lab should not be being used by a prosecuting agency, and for that matter, a defense attorney as well. The known or potential rate of error of the particular scientific technique, and whether the technique is generally accepted in the scientific community, as was mentioned already. This is not an exhaustive list, but these are some things for either party to bring up during the presentation. Motions in limine. Let me just say this. There's a trial motion in limine, something that's just basic. Judge, we're asking, you're on the day of trial, you're in court, getting ready to pick a jury. We filed a trial motion in limine, but those are what I consider short motions in limine that the court can adjudicate in a matter of minutes. Judge, we are asking the prosecutor not to bring up a prior conviction or whatever the case may be, assuming there's no 404B notice. That's something that's easy. But I caution you that if you're bringing up a substantive motion, Judge, we have a Daubert motion, and you're on the day of trial, well, I'll be praying for you. The judge is going to be all over you. You're going to get your head handed to you, because that's a major problem, because the judge does not want that jury to be waiting, and they will tell you that. And even on your short motions in limine, the judge may even say, we can take this up after we pick a jury. Don't forget about Rule 104, pretrial motions in limine. You want to hear something beforehand, don't forget about Rule 104. The government prosecutor as well as defense attorney keep that rule in mind. And that's all I have. Thank you.
Well, I want to thank Mr. Hall for this really comprehensive overview of the legal perspectives and the recommendations for presenting evidence and having a zealous approach to defense. And we don't have any more. We do have one more question for Dr. Rodriguez-Cruz. From an expert's perspective, is there any information or questions attorneys should ask experts?
Well, actually, in addition to obviously asking about education and training and experience and all that, when Mr. Hall was going through the 702 rules, there's two that we specifically point out as very important, actually, for our analysts, and that we consider part of our responsibility. And I would say that is something that definitely an attorney should ask. One of them, I'm referring to 702C, is that the testimony is the product of reliable principles and methods. And it may be considered sometimes, taken as given, taken for granted that a laboratory will be equipped with the appropriate instrumentation. And for those of you that are familiar with the terminology and the instrumentation, okay, the laboratory has a GCMS instrument, they have an IR, they have color tests. But it's the way we take a look at these rules is not only using these reliable techniques, and some of them have been available for decades, since 50s and 60s. It's not only using the reliable techniques that had been proven, documented. There's books. Undergrad students in science are taught how these techniques works. But it's not only about using those reliable techniques. It's about 702D. The expert has reliably applied those techniques and methods to the case at work. So not only did your laboratory bought an appropriate instrument or chemical technique to use, are they using it properly?
Right.
For the for what they said they're using it. And this is where the expert should be able to answer the question: has your method been validated? Is your method reliable? Is it based on an international standard? Does it fulfill minimum requirements for analysis?
And as they're answering that question, ask them why. Why has it been validated? And they will tell you, well, I presented at a national association for the last 10 years. I know X, Y, and Z doctors who are also reputable, and they will answer those questions for you. Scientific evidence can be very challenging when you, as a defense attorney or even prosecution, because you're in front of a jury. You want to make sure you're getting it right. And unless you have a scientific background, this can be hard to present in front of a jury. So you want to be asking the expert, what questions should I be asking to make sure the jury understands it? It does no good prosecution or defense if the jury doesn't understand what you're talking about. And then here's something I do need to say. Prosecutor or defense, look your witness right in the face and say, is there anything bad I need to know about you? Have you been arrested? You're going to do a records check anyway. Prosecutor, you're certainly going to do that. And defense is going to check them out. But look them right in the face. Is there anything bad? Did you beat up your wife last night or anything of that nature? I mean, because these things are going to be checked out. And the last thing you want is be in front of a jury and you get a bomb dropped on you, prosecution or defense. So those are things you certainly want to ask.
Okay. So there is one more question. How do lab errors occur? Do you want to take that on, Sandra?
Maybe questions that you are not often asked.
So that was part of the previous question.
Okay. And I wanted to add, and I'll delve into that latest question, and just to point out, as part of the training that analysts undergo in the laboratory, and I know it happens on the legal side that you undergo moot court exercises. We also attempt to do that, and to also train analysts and to how to answer questions so that the answers are understood by the members of the juries. And in fact, many laboratories have established liaisons with local legal offices where we actually have real attorneys come and do the practicing on the moot court. So one thing that is, I believe, not often done is pre-trial meeting between the attorney and the expert witnesses. A lot of the times we are told we receive a subpoena, we have to show up in court, and we wait a while, and then all of a sudden we're being asked all these questions, and maybe put either questions that are not being asked properly, or if you're not an experienced expert witness, if you're an experienced expert witness, you may be able to communicate with the attorney and know very well, say, okay, maybe are you asking this? And so, so a lot of that could be avoided. And it's better if the expert and the prosecuting attorney, in this case, that's going to be doing the direct examination, or if it's an expert for the defense.
And let me just say this: what you just indicated, you're in front of a jury. There's been no pretrial prep between you indicated prosecution and their expert witness. The train is off the track at that point. Because if the witness, let's assume you are saying to a prosecutor, can you ask the question a different way? Well, under Rule 611 of the Federal Rules of Evidence, 90.611 or 612 of the state rules of Florida criminal procedure, now I'm out of my seat, or the defense attorney's out of their seat, no proper Q&A. It assumes facts that are not in evidence. It's a narrative because you just can't run on and just educate. So there has to be the proper question and answer asked, and in order for that to be done, the pretrial meeting must take place.
And I must say, it doesn't happen often enough. For us, for many reasons, either time constraints or things like that.
On both sides.
Yes, absolutely. How do lab errors occur? Lab errors, these are you humans performing these tests. And do we have quality control procedures, quality assurance processes? Yes, absolutely. But typos happen. Inadvertent, switching of not a complete exhibit, but switching of a vial in an instrument with another. We do have procedures to do that, to correct for that, and they can certainly be explained. Every time, it doesn't matter how advanced the technique in the machine. If there's a human behind it, either performing, a calibration procedure that maybe a person forgot to perform, not with any nefarious reasoning behind it, but and these are, and there again, there's like second and third and fourth checks in many of the laboratories to
so
do
it's
that.
One of the requirements in accreditation is that there would be a peer review within the lab. So if an error has occurred, it is detected before it gets out of the laboratory.
Good.
So not only are we going to be using good procedures, good standards, good methods, we're going to use them in this case, and then we're going to have a check that an error has not occurred.
And that's what we want in this country. We want it to be right. Hey, this is the person who committed the crime. This is not the person, and that's all we want. Good scientific testing, and it takes any type of speculation out of it, and it reduces the innocent.
And the other question that's on the chat now is, are the lab errors documented? Yes, there is a procedure within the accreditation process that when lab errors do occur, for example, proficiency tests, all forensic scientists undergo proficiency testing. If they have committed an error in a proficiency test, That sets into motion a series of events, including documentation, remedial work, and more training. So there are mechanisms in place.
Yeah, and if I may add to that, within the scope of accreditation and when either an assessor comes in or also a lot of the laboratories perform what are known as internal audits. And if something is observed that somebody made an error and they discover, okay, yeah, this is an error that we should introduce something into the process so that that error never occurs again. It's what is called a corrective action. So they introduce a procedure so that whatever happened doesn't happen again. That evaluation procedure also involves reviewing. If it's a particular analyst that was discovered that he made a mistake, a lot of the times investigating that corrective action. There's a process of root cause analysis, and a lot of the times they go 6 months before, 6 months after the incident occur, if it was more than 6 months ago, and they see if there's more instances of that. There's also what are called preventive actions. In a laboratory system that may be composed of multiple locations, if there's an error that was discovered in one laboratory, a lot of the other laboratories can learn from that and start maybe an additional quality control check so that what happened there never happens here. So preventive action in this case.
And see, these are things that you want to be asking for in the discovery. Because I would imagine if a lab just continues to have so many errors and things, let's say 1,000 errors over a 6-month period, I would think the law enforcement agency is not going to use that agency anymore, or shouldn't be. But these are things that you're asking for in discovery. If that person who's doing the testing has a repeated rates of errors, you want to know that, because remember in the discovery, in our presentation, it talked about the weight. It's admissible, but it goes to the weight and credibility of the evidence, and that's what you want to attack.
So there's one more question. Is there a way to find if an analyst has a high rate of errors?
Yeah, that's in the discovery. You're asking for that under Rule 16.
Okay.
You're writing a letter. You can do it. I'm okay every now and then writing a letter to the prosecutor, but I really prefer motions because the case is documented. It's in the court record. We've asked for this. And this is certainly true when you're getting ready to go to trial, and it's a definite trial. You want to be making these requests already, and this is one of them.
They have to respond to that.
Yes, and you're filing your motion, turn over this person's going to be testifying, turn over this person's error rate and things of that nature.
Any final comments or observations by any of the panelists?
No, thank you so much for having me.
Thank you for the opportunity.
And thank you for joining us on today's webinar. Please continue to check the Spotlight section of our homepage on ncstl.org for information on upcoming webinars. All webinars are available on demand and can be found on the Education and Training page of our website. Please make sure to fill out the survey that you will be receiving by email. This survey will enable you to receive your CLE information. Contact our Office of Professional Education at ope@law.stetson.edu for further information or questions. On behalf of Stetson University College of Law, the National Clearinghouse for the Bureau of Justice Assistance, my guest speakers and myself, thank you for attending.